corporations question from July of 1995 gives us an excellent opportunity to take a look at a number of corporate law issues. Once again, this is principally a question that does not involve securities law, although one call of the question does bring 10b-5 into some consideration. Mostly, though, this is a straight corporations question, and it is one that only peripherally touches on securities laws. Take a look at the call of the question. We have a four-part call. 1. How should Polly's attempt to compel payment of a dividend be decided? Discuss. Well, this isn't going to require any internal organization to speak of, at least that's the way it looks, and also, we know the law up front. What rights does a shareholder have to compel a dividend? Answer, probably not too many. It all boils down to whether or not the directors are exercising reasonable business judgment in not issuing a dividend. We'll have a look at the facts. We will give a straight answer to this call of the question. 2. Can EXCO lawfully provide indemnity to Dan and the other EXCO directors for their costs in defending Polly's suit? Discuss. Again, we don't need to read the fact pattern to have some idea about how we are going to organize our analysis. With regard to indemnification, in the corporate context, it basically falls into three categories: mandatory indemnification, prohibitory indemnification, and a middle ground where there is some discretion with regard to indemnification. So we will think about that three-part checklist as a possible organizing principle and proceed. Call number 3. Are Dan and the other EXCO directors liable to Polly because of Dan's statement quoted in the Stock Market Times? And if so, to what relief is Polly entitled? Discuss. Well, this implies a 10b-5 issue. We'll look at it carefully, and assuming liability, Polly typically would be entitled to damages rather than other remedies. Although, if you are at all scholarly in the area of securities law, you'll know that technically plaintiffs sometimes have more remedies than just damages. And then, call of the question number 4, what responsibilities do Dan and the other EXCO directors have in seeking to effect the expedited sale of EXCO to MoreCorp? And have they fulfilled their responsibilities? Discuss. Well, here again, we don't need to read the fact pattern to have some idea about what the responsibilities of the directors are. They are fiduciaries. They have duties of care and loyalty, and more broadly speaking, they've got to act as reasonable business people in the same or similar circumstances. So this is a pretty straightforward four-part call of the question. As often is the case in corporations' essays on the California bar, really, we are being asked a series of short answer questions. This is not the sort of hard fact pattern that we find sometimes in contracts or real property or constitutional law, where we have to really scratch our head and think up some complicated theories of liability and then allow the analysis to play its way across a number of complicated lawsuits. Here, we've got 4 straight questions. We will give the examiners 4 straight answers. And to the extent the calls lend themselves to further internal organization, we will do it. So, now, please go to the top of the question, and let's have a look at the fact pattern itself. In paragraph 1, we meet Dan, the president of EXCO. He also is a member of the board and a 10% shareholder. So, he's an insider in several different ways. For the past 5 years, EXCO's average net pre-tax earnings of 50% of its gross sales, an excellent profit margin. During this period, EXCO has not paid a dividend or made any other distributions to its shareholders. This is planned so EXCO will have substantial retained earnings to enhance the chances of its sale to another company. That's an entirely legitimate business purpose for not issuing dividends. And by the way, although it goes beyond the scope of the issues presented here, it also would be a way for the corporation to avoid any accumulated earnings tax. I can't resist throwing that in. After all, I have actually been a professor in securities law, and like most professors, I can't help but throw in a little extra detail just for your edification. But the accumulated earnings tax is well beyond the scope of California Corporation's essay questions. All we're being asked about here is whether it would be reasonable to allow a shareholder to compel a dividend. And based on the information we get in paragraph 1, the clear answer is no, because the directors have got a completely legitimate reason for not paying dividends. And the shareholders are likely to be handsomely compensated for this comparatively wise exercise of business judgment. Let's look at paragraph 2. Here, Dan, with the approval of the other directors, has started sales negotiations with MoreCorp. Dan wants to complete arrangements for the sale on an expedited basis within the next 45 days because he believes that a brief present high demand for Exco's products will increase Exco's sale price. Again, a pretty reasonable business judgment, assuming it's true. Reading on. Dan has neither submitted the plan to Exco's shareholders for approval, nor has he obtained a review of the terms of sale by outside consultants. All right, that's starting to look a little dicey. It's starting to look like a breach of the duty of care to make sure that a decision this important is justified. Moving to paragraph 3, the negotiations are in progress. Dan is interviewed by the Stock Market Times, and Dan is accurately quoted as saying there are no pending discussions. All right, he is quoted accurately, but his actual statement is false. This is a misstatement of fact, and I think we can agree that it is almost certainly a material misstatement of fact. Read on. Now we meet Polly in paragraph 4. She is a 5% shareholder. She's concerned because she hasn't received dividends, and she has sued, seeking an order to compel the defendants to declare and issue dividends. And Dan and the other directors have voted to indemnify themselves for the costs of the defense. While the suit is pending, Polly has learned about the negotiations for the sale. She has amended her complaint to enjoin the sale and obtain damages from Dan and the other directors for the reasons explained at the end of the paragraph. And then, once again, we get the call of the question. And you know what? It doesn't look any more complicated now than it did when we first read it, before we even read the fact pattern itself. So, take a look at the outline of issues that I present, and you'll see I do find a way to really spread out our thinking a little bit and make it easy for our friend, the chain-smoking solo practitioner, to read our comments and obviously judge us to have passed this question. So, take a look at my outline for the first call of the question, with regard to Polly's attempt to compel a dividend. I explain in the first heading about how the directors have discretion, and then in the second heading, how the directors had a good business reason for not paying a dividend. Let me take a step back and confess something to you for a moment. It is unnecessary for you to have these two internal headings. Plenty of good passing answers to this question, just wrote a paragraph or two and moved on. I'm suggesting that it's appropriate to add these two internal headings, not because it makes your answer any more intelligent. It doesn't, but because it makes your answer easier to skim and easier for a disinterested grader in a hurry to tell that you know what you're doing. Ultimately, I reach a conclusion that, as you can intuit, is favorable to the defense. Next, we move on to the indemnification issue, and here I don't do anything more complicated than what I was intuiting right after reading the call of the question. I talk about mandatory indemnification, prohibited indemnification, and discretionary indemnification, and a separate, concise section for each one. If there's one bit of law you did not going into a review of this fact pattern, probably this indemnification issue is it. This is an issue that I don't believe the California Bar has ever tested before. Still, it's worth being aware of, and certainly it is a legitimate issue. Next, we move on to the question with regard to the statement. I focus on state blue sky laws and then 10b-5. You'll notice here I don't break 10b-5 down into elements because I think very little of Polly's claim. Ultimately, I do have a conclusion about the remedy that Polly will be entitled to if the directors and Dan are found liable. Next, with regard to the fourth call of the question, all I do is address the duty of care and the duty of loyalty separately, and then reach a conclusion. So take a look at this outline of issues, and I think you will agree that I have done an effective job in dividing and conquering four calls of the question that, on their face, are reasonably straightforward. There's no great mystery about the issues presented on this exam. The only question is, can we present a well-organized, rational, thorough, analytical answer under time constraints? With a good outline, that task is a lot easier than it would be otherwise. So, briefly, let's take a look at a few aspects of the answer that are worth paying some attention to. Look at the very first paragraph of my answer. As usual, I lead with the facts. I explain who Polly is and what her basic claim is. Then I move on to set up the procedural aspect of the litigation, and then I go into the analysis. The three-part analysis, the decision to pay dividends being within the discretion of the directors, the good business judgment of the directors, and a conclusion, frame the analysis. Notice that I explain in some depth how the laws and the facts relate to one another. Ultimately, my conclusion, I think a clear, correct conclusion, by the way, is that Polly's attempt to compel payment of a dividend will fail. I would note that I don't think there's any room for reasonable people to differ. I don't think there is any good reason for compelling payment of a dividend under these facts. Moving on, look at my response to the second call of the question with regard to indemnification. Here again, I briefly lead with the facts. That sets up the analysis. It makes the story a more complete and an easier story to follow. Notice here, if you didn't know the law before, this is a good time to learn it. If Dan and the other directors win their litigation, the board has to be indemnified for their legal costs, because these costs would be reasonably incurred by the directors in the course and scope of their employment as directors, and their good faith would have been proven in court. Thus, it would be unfair for them to face any personal liability, and the company has to indemnify them. A prohibited indemnification is the exact opposite. Suppose Dan and the other directors lose as a result of their own self-dealing, or that they are found liable to the company itself. Under both of those scenarios, they are personally liable, and it would be prohibited, illegal, and against public policy for the corporation to indemnify them. Finally, discretionary indemnification is the trickiest, and although I don't spend a lot of time on any of these isolated indemnification issues, this is the one that I spend the most time on. If the case is dismissed or settled, and the directors can still be said to have acted in good faith, it is within the realm of the reasonable for them to be indemnified. Next, we turn to the third call of the question, was there a breach by Dan and the other directors with regard to the statement? Here again, I lead with the facts, and in a couple of very short paragraphs and 3 or 4 short sentences, I set up the analysis. Then, in the following sections, I complete the analysis. First, we look at the state laws. Polly's state law claims would be based on common law fraud or misrepresentation. The problem is that this plaintiff can't show reliance, and she can't show damages. The statement was not made with the intent to induce or prevent action on her part. Neither did the defendant intend to harm the corporation. So the defendant wins in state court as far as I'm concerned. Next, we turn to 10b-5, and here, although ordinarily I would advise you to break it into elements and talk about the elements, here I don't think that we've got a strong enough claim to justify even that. The statement made by the defendant did not induce Polly to buy or sell shares, and consequently, she can't prove damages. So I would basically grant a summary judgment motion. I think this is a bogus claim and without merit. So, despite that, we go to Part C. What relief would Polly be entitled to if Dan and the other directors are liable? The answer is she could recover any damages that she suffered as a result of the misstatement, personally. And in a derivative action, she could cause these folks to have to disgorge any wrongful profit plus any damages that their actions caused the corporation to suffer. So even though I say she loses, since the call of the question asks about what happens if she wins, I give them a straight answer. I don't dwell on it because I don't think there's reason to do anything more than what I have done. Next, let's focus on the last call of the question. Perhaps an interesting call about the responsibilities of Dan and the other directors with regard to the expedited sale. We know that they owe a duty of care. Dan has an articulable reason for wanting to complete the sale quickly, and I state that reason. Still, Dan and the other directors have a duty of care to manage Exco. And it seems to me that if Dan's judgment about the necessity or the benefits of an expedited sale is true, then his conduct doesn't violate the duty of care. And the other directors have voted with Dan to approve this action. If it is reasonable, then the other directors also will escape liability. Next, with regard to the duty of loyalty, both Dan and the other directors have to act in the corporation's best interests. They may not use corporate opportunities for themselves. Here, I don't think this plaintiff can show any bad faith on the part of Dan or the other directors. And so, I conclude, again, that the defendants prevail, and Dan and the other Exco directors appear to be living up to their duties with regard to this expedited sale.